This conference will now be recorded.
Yes, okay, so welcome to the presentation for the James B. Seidel office's clientele. For those of you who are here by, your friend or your family member, you're welcome. You're more than welcome to join us. And usually we find that we're getting people from different states, and that's fine too. You can join us. We'll try to make this as non-state specific as possible. So joining me, well, let me go a little bit further here. All right, good. Introducing. So the presenter is myself. I'm at my main office here in Barboursville, Virginia. Sonia Rastici normally is a co-presenter with me, but Sonia is taking the Virginia bar exam in a couple of weeks, and so she is studying nonstop for that, and she has she's sort of on a leave of absence. So it'll just be me. However, Ron Smallwood, my associate paralegal, is here. He's waving. If you can see, he's waving, and he's going to help me on the technical side and maybe pick up some of the any of the chats that might occur. In fact, I see Ron. Did you chat me?
Yes, I did.
Okay. Okay, gotcha. So again, this is being recorded, and what we're going to do with this recordation is we're going to make it available on our YouTube channel starting sometime tomorrow. So just to let you know, the public will be able to see and hear what's going on during this webinar. A little bit about myself, in case you've forgotten. I'm a second-generation lawyer. My dad started the law practice 80 years ago during the war. I've been an attorney since 1980. I'm a former judge advocate with the Armed Forces. I concentrate in estate and business planning. Very few lawyers actually really do a true concentration in that area. I have a Juris Doctorate degree, and I have a Master's of Law and Taxation from William & Mary, licensed at Virginia, Maryland, D.C., and before the United States Tax Court and the United States Supreme Court. Member of the National Network of Estate Planning Attorneys. I should say a proud member. There's about 350 law firms that have gotten together. We've got our own limited liability state of Indiana, and we put out what I think are probably some of the best documents in the country. And so I have a roving practice, 1,300 clients, but if you multiply that by 2 of husband and wife, it goes up double that. And there's an introductory booklet which you are welcome to obtain, and there's more bio information on page 6 of that introductory booklet. I'm just going to run through Sonia's again. She's not here tonight because she's studying for the bar exam. She's got to put in about 10 hours to keep up with the pre-study for that. Just to remind some of you, I have 6 offices currently: Barboursville, Warrenton, Dillwyn, Fredericksburg, Fairfax, Bowie, and most of those offices we are seeing people. If people want to see in-person meetings, I'm having in-person meetings. The Warrenton office is in a Farm Bureau office, and they don't let people come in. But I think every other office I can see people in. I have 5 paralegals: secretary, managing paralegal, senior paralegal, assistant paralegal, associate paralegal. Associate paralegal is Ron Smallwood, and as I said, he's joining us tonight. During the pandemic, we're fully operational. We've been working harder than ever. We service clients by video, phone, mail, fax, in person. We're able to conclude all types of services. We practice, and of course, we practice as standard safety practices. And nobody in my office is symptomatic. So, and we're fully engaged and working hard as ever. Now, eventually available today is the introductory booklet. If you probably got that in the beginning, but we've got another copy of that if you want. Copy of today's slides will be available. The recording of today's webinar, evaluation, appointment, sign up, and there's a 5%. If you do follow-on work with us, we'll subtract 5% off the follow-on fees that we charge. You may have to remind me that because, okay, just to let you know, we are answering questions. So right now, I think I've got most people muted, so you're not gonna be able to ask a question now. But at the end of this, I'm gonna open it up for audio questions. But in the meantime, you can You can ask questions by chat. Ron will hopefully pick those up and pass those on to me. I'm not sure if I'm going to be able to do much answering until the end, but you can at least go ahead and ask those questions. Okay, so what we're really doing here is we're reviewing your current plan and giving you some ideas of what we have experienced when people come back. And we're doing a lot of prior client work during the COVID. I think where people are coming back to have their documents reviewed. So before we go further, I want to get estate planning defined. This is our approach to estate planning. I want to control my property while I'm alive, take care of myself and my loved ones if I become disabled. And I want to give what I want to whom I want, the way I want, and when I want. And if I can, I want to save every last tax dollar, professional fee, and court cost possible. And that really is exactly what we accomplish every day. We believe that we're saving people literally tens of thousands of dollars and avoiding as many family conflicts as possible. You should have in your documents an annual business and planning review. This is hard to read, but the point is that we would like to see everyone once every 3 years. All you got to do is call my office to set up a review meeting, and Linda, my secretary, will get you on board. But the reason I have this review form up is that if there are any yeses to this, you might want to come in earlier than the 3-year period. And I'm going to show you some of the things that drive people back into the office for a review. Okay, so there are different types of packages that you might have from this office. Our most common is a living trust package, which means you have a living trust plus other documents such as a power of attorney, will, medical directive. Traditional will package would be all the documents except the trust. Business entity package, if you've done, say, a limited liability company, generally will have a complete binder and a set of supplementary documents to the LLC. And then some people may have just done a la carte planning, Medicaid planning trust, special needs trust, standalone beneficiary trust, or maybe on occasion people come in and just have us do a power of attorney for them or a medical directive, something like that. So you're into one of these typical categories. So one of the things we do, one of the reasons I like the 3-year review is it gives us an opportunity just to kind of go through the documents, make sure they're all up to snuff, make sure that we've kept up with any changes in the law or changes in best practices. Here are some of the questions we asked. Do you have all the needed documents you need? Are your documents up to date? Are your fiduciaries current? And are your beneficiaries current? Those are some of the standard things. And you'll be surprised how many people will start out the meeting by saying, I don't think I really need any changes. And by the end, we find that we do sometimes need quite a few changes. The most common change we find when people come back for reviewing is changing their fiduciary. A fiduciary is simply a generic term that applies to executors, attorneys in fact, medical agents, trustees, and guardians for minor or disabled children. So executors under the will, attorneys in fact under the power of attorney, the medical agents under your advanced medical directive, trustees under any trust you've set up, and guardians for any minor or disabled children. So that's 1, 2, 3, 4, 5 types of fiduciaries that we look at, and it's usually people wanting to change those fiduciaries, which is a prime motive for coming in. By the way, a typical phone call we'll get is, I want to change my executor. And it turns out that not only does the person want to change their executor, but they want to change these other fiduciaries as well. And that's one of the things we'll go through with you when you call. Why changes? Sometimes children have grown up, so maybe we started when they were minors. Now they're old enough to be a successor trustee, for example. Or you want to change the relationship with an appointed fiduciary. Maybe you've named somebody, they passed on, or you haven't heard from them, or you've got somebody you'd rather move up in their place. So this is, like I say, is the most common reason people come back. And then once we once we determine that, we usually set you up for a phone call, and we'll go over your complete package to make sure there's not any other changes to be made. Because if you're going to make, say you're going to change your trustee, and there are other trust amendments you want to make, you might as well get them all done at the same time, because it really keeps costs down that way. So here's 8 other changes that we commonly meet when people come back to have their documents reviewed. Changing your beneficiaries. Sometimes people want to disinherit somebody. Sometimes people want to include a new child or an adopted child. People want to change specific gifts. Maybe the last time they gave a specific gift to this charity, now they want to give it to another charity. Maybe your marital status have changed. Maybe you've been a change in health. We do quite a bit of documents for people with health changes. Just did one yesterday, major health change for the husband, and resulted in us making a lot of changes to protect the estate from medical bills and nursing home expenses. Changing finances and assets, changing your tax status, or you've moved to another state. And I try my best, if you're moving to another state, to offer my continuing services rather than going to the out-of-state lawyer starting from scratch. We offer our services. So I've got clients, seems like in every state in the country. That's not the truth, but it seems like that way. For those of you who have businesses, by the way, if you haven't incorporated or organized your business, this is something we recommend at least you talk it through. And at the end of the time, you say, well, we really don't need to, we don't have it organized, but we want to keep it that way. That's fine. But at least find out what an organized or incorporated business can do for you. These are some of the things that we will do for people who are returning to us with existing businesses or have new businesses. Are you conducting your annual meetings? Changing ownership, changing business assets, changing registered agent, changing officers of the business, need to incorporate, need to domesticate the business in another state. So maybe you started out doing business primarily in Virginia, and now you're doing business in Maryland or Pennsylvania or District of Columbia, and we want what's called domesticating that business in both of those jurisdictions and all the jurisdictions, so you get covered in all jurisdictions. Because one of the primary reasons you do a business is to protect your personal estate from lawsuits. I'm just dealing with an awful case right now where someone's getting sued for $1.5 million. And the judge, I think he really made a mistake. He's allowing the plaintiff to proceed against the personal estate of the client. And so we're doing some circling the wagons without sending anybody to jail. So we can protect the estate in case they win the lawsuit and we got a $1.5 million claim against the estate, which means they could maybe liquidate real estate. They could force garnishment of bank accounts and so forth. Okay. Ron, join in if you've got anything you want to add. I know Ron has told me he's a retired lawyer, and I know, Ron, you've said in the past that you've, I think, successfully attacked businesses that don't conduct their annual meetings. Is that something like that? Am I right on that?
That's correct. If you want the protection that the state offers you, you have to do certain things. And one of them is keeping your annual minutes current, paying your registration fee with the State Corporation Commission, of course. And if you don't do that, and the other lawyer subpoenas your records, and they find out, well, I use one checking account for my personal stuff and the same checking account for my business, and no, I haven't done my minutes for 5 years or paid my fees, then the judge is going to say, well, that's not really a business, that's just you. So I'm going to allow the plaintiff to pierce the corporate veil, and that means he's going to sue you personally, and whatever you had protected is no longer protected by the LLC or the corporate structure that you created. So it's very important to keep these things up. That's what the judge looks at. So if you don't do your homework, you could lose your asset. And yes, that does happen. Uh, most people don't think it's important, but or I can do it now. No, you have to show a track record. So that's we do a lot of that. That's why we recommend every 3 years we review your minutes to make sure your minutes are up to date and correct, and list all the information that the Code of Virginia requires you to put in.
Yeah, and people are of course able and willing to do their own minutes. The advantage that we bring to the table, if you want us to do the business meeting minutes, is that we're a lot more thorough. We bring up a lot of different. I mean, our standard form is about, I don't know, 5 or 6 pages long, and it covers a lot of bases. Where if you do your own, you might only cover a few bases. So, okay, so one of the reasons people come back for reviews is they want to make sure that we're up to date as far as state planning laws that have changed and changes in best practices, which are constantly on the change. So I'm just going to hit a couple of some recent law developments. State tax laws have changed drastically in some cases for those of you who haven't been back for a while, and we'll go through those. Health insurance, the old HIPAA again. These have been pretty standard for well over 10 years, but some people with older documents might not have HIPAA waivers, which means that people might not be able to access your records when you're disabled. And that presents a real problem if we're trying to access your medical records to determine things like, are you incapacitated, or what kind of records or what kind of situations might be applicable to your medical directive. So HIPAA, Virginia, Maryland statutory law changes. Virginia, for example, has changed a lot of their typical state planning codes, and those should be updated. Virginia's tax on motor vehicles, there's been a change on that. And what we've found is during the COVID crisis, it's important to do your medical directives, make sure you're up to date, so that doctors are in the early phases. Doctors were actually making unilateral decisions about who would be taken off respirator machines. I think we've gotten through that, but the point there was the doctors were making the decisions rather than your spouses or your children or the people you wanted to. And your medical directive will dictate that, and the doctor's not allowed to override that without there being some huge reason for doing that. Funeral directives, we've gotten more specific about these. And then the Secure Act of 2019 and retirement plans has affected inherited IRAs. As a matter of fact, I had a call just from a client today, prior client, and that he paid me $300 just to walk through the Secure Act and how it affected his IRAs going down to his children. Mm-hmm. So some of the best practices, some of you may have documents that do not have trust protected provisions. This is it's not a new law, it's a new practice method. And what it does is it allows us to change the trust even when you're disabled or deceased without having to go to court. So we'll save the $3,000 or $4,000 or $5,000 necessary to go into court to get the trust changed by simply appointing a trust protector who then is authorized to make changes in the trust. You can see huge advantage. I've used it 2 or 3 times, and it's really a great way to change the trust when you're not able to do so yourself, but your trusted trustee chooses a trust protector to make those changes. Asset protections, this has changed. Asset protections for like children and for surviving spouses, those have tightened up. Managing fiduciaries when co-trustees are appointed is another practice. Let's say that you have 3 children and you'd like all 3 of the children to name as to serve as co-trustees. Well, we can name all 3, and then we will name a managing fiduciary. as trustee. In fact, the last case I was working on prior to this presentation was someone who had managing trustees. And I think it was three children, and they want one child to be the managing trustee, and then the others would be simply sort of like voting members, but they don't run the day-to-day operations of the trust. No contest clauses, we've expanded on this. What we're trying to do is we're trying to avoid unnecessary lawsuits against the estate. And so what we say is if someone wants to sue the trustee, they can do that, but then they lose their inheritance. It's kind of a poison pill. I mean, unless they've got, unless they're suing the trustee for fraudulent practices. But so this keeps lawsuits down. I think of my 3,500 cases, I think only about 3 or 4 of them have gone to court. And that's because usually people waive the no contest clauses so they can get a court ruling. But most of my cases, the vast majority, 98% of them, I've kept out of court. Limited power to invest, limited power of appointment. This is really a great thing for like if you're going to leave distributions to your children in trust. There is some controversy over whether or not those trusts are taxed at a higher rate or not. These powers of investment and powers of appointment is a technical way to have children receive inheritance but not pay a higher tax rate. Generally speaking, trusts, not the living trust, but the resulting trust of kids can be taxed at a higher rate. And these powers to invest and the powers to appointment is a way of avoiding that, and the trust is then taxed at the child's rate, which is usually considerably lower than the trust rate. So those are new things that have developed that older trusts do not have, and the newer trusts now have. Okay, Ron, any comment before I go on here?
Nope, I'm fine.
Okay, so we're just going to hit here a little bit about changes in estate taxes. We're not talking about income taxes here, but estate taxes. And in Virginia, in 2007, the Virginia repealed its estate taxes, so Virginia no longer has an estate tax. So if for those of you who have a trust set up with estate planning because of Virginia taxing you, you don't need to have that anymore. Maryland has a $5 million exemption. So that's considerably below the 11.5 million for the federal government. So Maryland, we find our Maryland clients, we have a tendency to have more state tax planning trusts. That an estate planning tax trust will double that 5 million to 10 million. So I realize that's beyond a lot of people's concerns, but there are a few people that this is a problem. Just to let you know, if you're in Maryland, Maryland also has a 10% inheritance tax on what they call collateral heirs. That would be nieces, nephews, and friends. So let's just take an example where on occasion this will happen where people will not leave anything to their kids, but they'll leave things to their nieces and nephews. And those distributions will be taxed at 10% in Maryland. District of Columbia has a $5.1 million state tax exemption. So again, we find our DC clients needing estate tax planning more than, say, Virginia, because in District of Columbia, if you have over 5 million, you're going to be taxed at the District of Columbia state tax rate. I want to say it's 9%. I forget what it is, but it's not as big as the 40% at the federal level, but it's still enough to be concerned about. So those are Maryland, Virginia, DC estate inheritance tax law changes over since the last probably 5 or 6 years. Changes in federal estate tax. So remember, when you have an estate, you have 2 people prying on you as far as getting taxes. One is the federal estate tax and one is the state estate tax. We just talked about the estate tax, and here's the federal estate tax. So you can see over the years in the left, it's kind of hard to read all this, but there was a point where if you had $675,000, you were taxed at as high as 55%. Now, if you go down to the bottom on the left, in 2020, you were exempt if you had under 11.8 million. So most of us do not have to worry about estate taxes. So if you've got an older trust where we did estate tax planning, one of the things we'll talk about in a review is, do we need to really do that? Because it's kind of a complicated thing to do this. There can be good reasons to do that. I've got a chart coming up that will show that. But if those reasons don't apply to you, we might want to do away with the complications of having an estate tax planning. By the way, an estate tax planning trust will add about, well, it's about 12 to 15 pages, and all of that can be deleted if we don't need to do it. Okay, so estate planning overview. So we have typically two primary packages. You're going to be in one of these two packages. One is the living trust package. The other was the will package. The living trust package has a living trust agreement and along with what we call ancillary documents, financial power of attorney, medical power of attorney, wills, and funding instructions. Your will package has what we call the traditional will, financial power of attorney, and medical power of attorney. A la carte planning, business planning can be added to this. So let's just take a look for those of you who have a living trust, real quick review on that. So this is a slide that shows your living trust right here. This is a joint living trust. Some of you who are married may have separate living trusts. That's more of a standard practice, especially in Virginia. I have more of a West Coast influence where we combine husband and wife trust into one trust. I feel it's a lot easier to handle. There's less paperwork. And as long as you and your spouse are of one accord, I think it's the better way to do this. If you have estate tax planning at the death of the first spouse, you can see it splits between the family trust, that's the green box, and the pink box, the marital trust. So this is what we'll do if we have estate tax planning. Nonetheless, we might want to do this. If you look in the pink box, another reason for doing this split out is because we can protect the estate from the surviving spouse's problems. So for example, husband dies, wife gets sued, or wife has a remarriage and they're getting a divorce, or wife is in a nursing home, or wife has other creditor problems and they're coming after her assets. If we have this family marital trust set up, we can protect the husband's or the decedent spouse's share from the surviving spouse's or the wife's problems during her lifetime. And this is really a very useful way of protecting up to half of the estate from the surviving spouse's problems. So if you've got an estate tax planning trust in place, we might want to keep it going just for this reason, because even though we don't need it for estate tax planning, we can need it for for protections against creditors. And then at the death of the surviving spouse, then it drops down to the children, and there's a whole variety of children's trusts. We'll get into that in a few minutes. So that's kind of an overview here. Notice on the upper left, there's the assets going into the trust. If you have a living trust, you've wasted your time and money if you don't have it funded. Funded means you have to have assets that are owned by the trust or designated to the trust. If you haven't done that, then you're wasting your money. And it's very expensive to probate assets that are not in a living trust. I mean, you could be spending, a couple of years ago in a Maryland case, we spent $3,500 in probate expenses to probate a $10,000 bank account. Had the $10,000 bank account been in the trust, which were most of the estate was, we would save ourselves $3,500. You might go on and on other assets as well. So that's kind of your overview there. Five general advantages. People sometimes need to be reminded, and I have people come back and say, why in the heck did I get myself into this thing? And this is 5 general advantages to kind of remind you of what it is. First of all, it covers before and after death planning. There's no other plan out there that does this. Your will plan does not cover you before death. It only covers you after death. The living trust covers you before death and after death. And what are we talking about? Before death, we're talking about disability. You are disabled or something else is going on where we want to protect your estate. After death, we're protecting you from things like probate. Voids conservatorships, voids probate proceedings, improves beneficiary planning. All kinds of neat things can be done on a living trust that you typically would not do in a will plan, because your will plan is going to be subject to court oversight, whereas your living trust, which is a private document, you can do neat things without having to have some commissioner of accounts mucking up the problem, what you've tried to do. And generally speaking, your living trust simplifies and increases control. So those are the 5 reasons. They're very strong reasons for doing this. And we really believe in what we're doing. We're passionate about this. And we think every day we're helping people plan their estates better and estates that work in the long run. So for those of you who have a traditional will, here would be an example of a married couple with an I love you will. I love you will simply means that at the death of the first spouse, everything goes to the surviving spouse, and at death of the surviving spouse, it comes down to the beneficiaries. If you don't have anything, or if you know somebody doesn't have anything, like for example, your children are in their 20s and 30s, they ought to have at least a basic will in place. What are some of the benefits? If you look in the bottom left there, it names executors, beneficiaries, guardians for minor children, waives bond, and creates trust if you want to do that. Huge advantage to having this decided by the court. So if you die without a will at all, then the court's going to make these decisions for you. And I can almost guarantee you that they're going to make decisions that are contrary to what you would have made had you had that opportunity to do so yourself. So your will planning is far superior to no planning at all. And you can tell if you compare this to the living trust, it's not as good as the living trust, but it's a good. And remember, your will requires probate. Sometimes people think a will takes you out of probate. That's not the case. It takes you into probate, but it gives us guidance that we don't have otherwise. So probate is the legal court process for proving the validity of a will and for distributing your assets to your heirs. The average length, by the way, of your probate is 18 months. So it's a slow process, as is so many government proceedings. And in about 25% of the probate cases, it's still going 3.5 years later. So it's a slow process and it's expensive. Your average cost is 8 to 9% of the probate estate. I'm handling a probate case now where they've hired us to do everything, and I think our fees are going to easily be $20,000 to $30,000, and it could be double that, but we're really working hard to keep costs down. So probate's a very expensive, very time-consuming process. The living trust keeps you out of that. The will takes you into probate, but at least makes it easier because it'll tell us things like who's going to be the executor and those kind of things. Probate proceedings require an inventory and 1 or more annual countings to the Commissioner of Accounts. So if you have a probate estate because you have a traditional will, the first thing the executor will do is take the will to the probate clerk, get it admitted into probate, and that triggers a whole set of guidelines or requirements, one of which is to file an inventory within 4 months, and then to file annual countings an accounting every 6 months. This is taken from a book called The Living Trust, done by Henry W. Apps. Henry, I was a good friend to Henry when he was alive. He came to Virginia, and we did a number of seminars throughout the state of Virginia. This was his depiction of probate. It's hard to read this, but you get the idea of how complicated this probate process would be. And the problem with probate is that, well, a lot of people say, well, I probated my dad's estate or, my friend's estate, and it went pretty smoothly. And indeed, a lot of probates go relatively smoothly. But you can see in this chart, if it goes to the left or the right, you get caught in one of these boxes and you can be going for years and years. Okay, changes to your beneficiary. So one of the reasons people do estate planning is, hey, they want to get their estate down to their beneficiaries. And once you got those set in place, then the question is whether or not from time to time you're going to make changes. And here would be some reasons why you might want to change beneficiaries. The beneficiary has passed away. A beneficiary has become disabled. I have a very painful case where a parent's child was hunting, and he was up in the sitting up above in a tree, and it came loose, and he fell down to the ground and is now a lifetime paraplegic. So we're doing some special things to protect his estate from those problems. Gone through a divorce. Beneficiaries have gone through divorce. Sometimes parents will even name in-laws as co-executors, powers of attorney, and of course, when a divorce occurs, you want to consider changing that. Maybe children have acquired significant debt that we want to avoid having to be pulled into an inheritance. So keep in mind that when you inherit property to a child and the child has got a lot of debt, the debtors can come after the inherited property. So we might want to set up a trust that would protect the inheritance from creditors. And sometimes we just want to disinherit or restrict a beneficiary. Beneficiary's gone off the deep end, and don't be embarrassed about this. You'd be surprised how often this happens where we have to disinherit or further restrict a beneficiary has proved themselves not to be of sound mind. So these are some of the reasons for changing beneficiaries. This is one of the things we do in our reviews. You may say, well, I don't have any problems, but it doesn't hurt to go through the checklist to see if that in fact is true. Now, one of the things we do for beneficiaries, we'll set up a subtrust. So when you make distributions to a beneficiary, you can do it what's called outright. Outright is, here's your inheritance, make good decisions, end of story. So there are all kinds of options to outright gift distributions, and these name some of them. Marital trust. The advantage of the marital trust, as we mentioned earlier, would protect the surviving spouse against the surviving spouse's problems, be it lawsuits, bankruptcies, divorces, and nursing homes, and that kind of thing. Inheritance protection trust. These are where we want to protect the child's inheritance from problems they might have. Common trust. This allows us to name multiple children on one level, and we'll let a trustee decide who will get how much when. So we have sort of a common pot trust. And we have general needs trust. These are trusts that are designed to give children distributions for their general needs, generally defined as health, education, and maintenance. And then at a certain age, we give them whatever's left over. Lifetime trust. This would be for children who need lifetime estate. I do this for bigger estates. I do this where children have drug or alcohol problems. I do this for children who have problem marriages. We're concerned about a divorce. We want to protect the estate from the divorcing spouse. Special needs trust. Special needs trust is for children that have a disability, a severe disability. I have a child that has severe autism, and so he has a special needs trust. The special needs trust allows that child to receive inheritance without disqualifying the child from government benefits. So my son Jimmy will be able to receive a significant amount of my insurance, for example, and not lose government benefits that are otherwise available to him. In fact, here's a picture of my son Jimmy's, and that's me. And this is, we were on a cruise. And so this is a picture of him. And we've got a guardian appointed for them. If you know of anybody, or if you do have a disabled child, you ought to consider having a guardian appointed. So myself and Jimmy's mom are the co-guardians. We have our daughter as the backup or standby guardian. And then on top of that, his inheritance is being held in a special needs trust. So you can give gifts besides timing when they get it. We can talk about specific gifts and what's called remote heirs. Specific gifts would be, for example, gifts to children, grandchildren, nieces and nephews, brothers and sisters, charities, best friend, your church. So sometimes parents, for example, or grandparents want to give something for a college education program. So they can do that and give a specific gift to a grandchild. And I understand, last time I looked at this, those gifts did not disqualify a child from receiving school aid. If the gifts are made from parents, then that can disqualify them, but it's made from grandparents, they're not disqualifying gifts. You can give gifts to a favorite niece or nephew, to a favorite sibling, charities. I get a lot of gifting to charities. Your best college friend, your church. These are specific gifts you can make. Sometimes people will want to do these when they review their cases. In other cases, people will want to cancel them. Well, last time we gave $10,000 to the SPCA, but now we want to revoke that gift. Remote heirs. Everyone should have a remote heir. This is in the case where all of your primary and contingent beneficiaries pass away before you. I know it may seem like this never happens, but last year there was 2 cases that made the national headlines where entire families were wiped out. One was the duck boat incident where 23 people of the same family drowned when the duck boat capsized in a windstorm. And another case where the entire family was in a large limousine and the limousine went off a cliff and the entire family was passed away. So, remote heirs would cover those scenarios where you define who would get in those cases. Typically, we just simply say next of kin, but just lay that out and be done with it. Changes in spousal planning, death of a spouse. So, for those of you who have had the awful experience of having a spouse pass away, I just had an extensive meeting with a client yesterday whose spouse passed away of Alzheimer's, and so we want to meet with the client. We want to meet with you. We want to see if we have a family and marital trust, we want to activate those. Do we have a probate? Because if maybe we don't have everything in the living trust. Do we want to remove the deceased spouse as a fiduciary in all documents? Don't necessarily have to, but if you don't remove the deceased spouse, then every time you got to have an original death certificate to prove the spouse has been deceased, and you got to go through that whole process. Where if you remove the spouse from, say, the power of attorney, then we don't have to prove every time we use the power of attorney. We don't have to cough up an original death certificate to prove that the spouse has been is deceased, and we move to the second name power of attorney or executor. If we do that right up front, then we don't have to go through that process. We want to make specific gifts that are directed by the spouse. So if the surviving spouse says, I want $10,000 to be given to my, favorite nephew, then we would make that gift at that time. And then we want to update the estate and business plan. So there might be changes you want to make when the spouse passes away that maybe you didn't want to make before. Spouses with mental disability. So this is a case where your spouse is living but is mentally disabled. And if this is the case, then you really need to have a review meeting. We need to go through all the documents to see what we can do. And so these are some situations: cognitive disability, nursing home. Have you removed your disabled spouse as a fiduciary? So here again, it's more complicated to get this done if we haven't actually taken the spouse off, because frequently we have to have 2 doctors' letters certifying that the spouse is unable to handle his or her affairs. Then we may have to have an affidavit on top of that, and then we have to present the power of attorney, and then we present the doctor's certificates and the affidavit, and that allows you to proceed as if the spouse were never named. So an easier practice would be simply to do a new document and remove the spouse from your power of attorney or trust or executor or whatever. So those are some of the things we do when we have a mentally disabled spouse. This is a chart that shows the increase in nursing home. Probably no surprise to many people, but in 2004, your annual private nursing home costs were about $65,000. Now they're over 100,000. So it's a concern. How do we deal with paying for those nursing home expenses, and if all possible, hanging on to some of the estate? But by the way, the first trust I ever did was my mother, who had Alzheimer's and was in a nursing home for 7 years. And by doing good estate planning with use of a living trust, we protected the family home and about another $250,000 on top of that. So, okay, so the other problem, of course, is a case where you've divorced your spouse, and in those cases, we definitely want to update your will, power of attorney, medical directive to remove the former spouse. We of course want to comply with any property settlement agreement. A typical property settlement agreement would say, for example, you've got to maintain a life insurance policy on your surviving spouse, but you can still, as far as I'm concerned, put that life insurance into a trust and name somebody else as the trustee of that trust. It still goes to your former spouse, but now it's controlled by your trustee, who can make sure that it's not going to be squandered or given to maybe a new boyfriend or girlfriend or whatever. We want to remove the spouse as a fiduciary, most likely remove the former spouse as the beneficiary. Sometimes the law automatically states that the former spouse is the beneficiary, but not all the time. And it's better to take the spouse off rather than take a chance that the law will automatically exclude this former spouse. Name trustee for distribution to minor disabled children, a particularly important time. And if any of you have children that have gone through a divorce and they have minor children that are in custody of the former spouse, we want to set up a trust for that child of yours so that it doesn't go to the directly to the minor or disabled child controlled by the former spouse. Instead, it'll go to a subtrust that you will name someone who will be in control of that money, and the former spouse can come to that trustee, and the trustee will have the power to say yay or nay to distribution, so it doesn't get sucked up in things that you would not approve. Divorced spouse, you might also want to make changes to your business documents. Remove former spouse as a member, shareholder, registered agent, officer, director. You want to notify your spouse, because you could take a spouse off as a attorney in fact, but if your spouse doesn't know it, then the spouse might act under the old power of attorney, which gave them authority to do things like take all the money out of the bank account. So you want to notify the former spouse that you've been taken off as a fiduciary. And don't assume if you've been through a divorce that your divorce lawyer has done this or even knows how to do it. I mean, I don't know. I would never advise people too much on divorces, because I just don't practice that area of the law. So similarly, your divorce lawyer doesn't know much about estate planning. Yeah, okay. So, and then there's the remarriage. There's a situation where, okay, so now you're either getting married for the first time or you're getting remarried. So, you want to consider a premarital agreement, or even if you have been remarried, you can do a postmarital agreement. Keep assets separate from each other. This is particularly important for older people who are getting married. They have separate children, separate assets. Might be a good idea just to do separate. This would be a case where instead of doing a joint trust, we want to have separate trusts. Do we want to name the new spouse as a fiduciary? Maybe yes, maybe no. Maybe we want to name the oldest child as the fiduciary rather than the new spouse. What about how do we deal with joint separate children? If we have children together versus children from prior relationships, that's always an interesting challenge. And then separate trust versus joint trust. Sometimes when people have gotten remarried, we've done joint trust with a new spouse. Sometimes we've done separate trusts, and it just depends upon the situation. And on the remarriage, slide number 2, again, if we want to keep stuff separate, if we have separate bank accounts, we want to perhaps keep those separate. We want to add a marital trust for the new spouse. This is nice because this would allow you to distribute some or all of your estate to your new spouse but then your children from your prior marriage are locked in rather than your new spouse's children from his or her former marriage. So therefore, we're able to pass things down to your former spouse for a lifetime, but then it goes to your children upon your spouse's death. So that's an interesting use of a marital trust. Changes to your business plan, and you want to pay particular attention if your new spouse is a non-U.S. citizen, because there's special things that we want to do to protect the estate from a non-citizen who are typically taxed at a much higher rate and a much quicker rate than a citizen spouse. Okay, so Ron, you might want to join in on this funding of the estate plan. Got anything you want to say off the cuff on funding your plan? Ron does a lot of help on funding living trusts.
I get calls from people who say, my husband died and he didn't put his checking account in the trust and it's $20,000. What do I do? I say, well, you give us about $3,000 to $4,000 and we'll go to probate court and get that $10,000 less our fee for you. So it's something you need to review every once in a while. People buy new cars and don't put them in their trust. They may open a brokerage account and forget to put that in their trust. And after the first person has died, then it's a problem because it's going to go through probate. Now that means it's going to go through the pour of a will into probate, and the Commissioner of Accounts is going to get involved. They'll charge you fees, and it'll take 2 years at least. Then eventually, the judge will say, okay, the pour of a will says that everything that wasn't placed in the trust will now go into the trust. So I'm ordering that the executor turn over these assets to the trust. So you have wound up having your assets in the trust, which is good, but you've had to go through probate and wait 2 years at least before you can do it and spend $4,000 or $5,000. All of that could have been avoided if you reviewed your plan and made sure you had all of your assets titled to your estate plan. Now, the other thing is that once a spouse has died, the surviving spouse inherits the IRAs, the 401ks, etc. But they forget to put a new designation, or they put one of their children on there. That means the trust will not control that. It will still go to probate, and you go through all the process, and eventually it gets back in your trust. So once you have this vehicle to protect your estate, you should spend some time making sure your funding is correct. Now, if you don't have your funding sheet or can't find it, call our office and we will email you a new funding sheet so that you can use that as a checklist. But it causes a lot of problems after the first person has passed away.
Thank you. Yeah, I tell people if you've got a living trust and you haven't gotten it fully funded, to the extent that you haven't funded your assets to the trust, you've wasted your time and money. So get it funded. That's another reason for giving us a call. As part of our review, we'll go through the checklist that Ron mentioned. We got a nice checklist that goes down all the 10 or 12 different types of assets to see if it's been properly funded to your trust. Now, so I also say we're talking about living trust, but there's also, even in a will, if you have a traditional will plan, you've got to be thinking about funding. I call funding the will, typically not used with reference to wills, but you could do it. Will and asset passed by joint ownership, will and asset passed by beneficiary designation, will and asset passed by your last will and testament. So when you have a traditional will, there are 3 options. This is why really a will is more complicated than a will. A will is more complicated than a trust. And that's because you've got to decide, is the a particular asset going to go by joint ownership? For example, if you have a bank account jointly owned with your son, then it would go to your son. Typically, joint ownership rather survivorship. Keep in mind that that would mean that your other kids will receive nothing. We've got a case going on right now where the unbeknownst to us, the decedent's person, he was a single person, named one of his daughters as the beneficiary of about a $20,000, I think it was a bank account. And we know he did not mean to do that. He meant to give 1/3 of each of his children, but that daughter is walking away with $20,000, about $14,000 more than she's really was meant to receive. But that's just the way the cookies crumble. We're going to be asking for her to unilaterally gift some of that back to her siblings. It remains to be seen how she's going to react to that, because she doesn't have to do that. Will the asset pass by beneficiary designation? So life insurance and retirement plans, for example, are passed by beneficiary designations. Or will the asset be passed by last will and testament? The last will and testament has its own set of distribution schemes that may or may not be the same as distributions by beneficiary or joint ownership. So you can see that's the complication, and we'll help you work through that. So living trust, your living trust, we want to make sure it's funded with real estate. So if you've bought since you've done your living trust, you bought a new house or a new beach house or a timeshare, you want to make sure those are titled to your trust. Okay, if not, they're rogue assets, and only time will tell how they'll be played out. Bank and investment accounts need to be titled to the trust. Automobiles, unfortunately, the Department of Motor Vehicles is probably, of everybody you got to deal with, is the most difficult. So we kind of go either way on automobiles. That's one asset that about half of our assets say, half of our clients say they're not going to retitle the vehicles because of the DMV. We do have a little trick about signing the certificate, the vehicle certificate. Ron, you know what I'm talking about?
Yes, if you have the title to the vehicle, at the bottom there's a place for seller and buyer. If you, whoever is titled to signs the title in the seller column, but does not date it, when you put it in your trust binder, then if something happens, become disabled or pass away, then your successor trustee or disability trustee can then negotiate that vehicle. Either you can't even junk a vehicle without a title. So if it's going to be sold or given to one of your children, etc., or to a charity, they can put the date on it and convey it. And that's a whole lot easier than trying to get DMV to do something. DMV also has a form whereby if a person dies and the vehicle's in their name, the heirs can fill out a form, but that requires the spouse, if the spouse is still alive, plus all of the heirs would have to sign it, which is very cumbersome. There might be one person says, well, no, I'm not going to sign it. Then you have a problem. So if you have a question or you're still confused about that, give us a call and we'll walk you through that.
Okay, great. And we want to make sure life insurance policies name the trust as a beneficiary. Retirement plans, we always encourage married people to name surviving spouse first, so the surviving spouse can get a tax-free rollover on retirement plans, and then name the trust second. You want to make sure your business plan is assigned to your trust, and that there's some kind of, if there's any special planning, like you're going to give the business to one child, that's really nailed down either in the business document or ideally in the trust document itself. Couple of things, couple of final marks on businesses. I think I've covered a lot of this. Unincorporated businesses, these are some of the problems: lack of creditor protection, ownership unclear, tax assets unclear, tax status unclear, no centralized management. If you have an unincorporated business, there's just so many critical decisions that are not being addressed. So, okay, so we're in the home stretch here. State and business planning, the review process. So if you do come in for a review meeting, and I know sometimes people call up and say, why do I need a review meeting? And sometimes you don't. More often than not, we're going to encourage you to have a review meeting so we can make sure we cover everything, maybe even a bunch of things you haven't thought about. So we're gonna ask you to do an updated intake form, state inventory, network statement, unless it's less than 3 years old, then we'll stick with the old one. We're gonna review changes needed or recommended to your documents. Sometimes we'll do a restatement of documents. Sometimes we'll just amend the documents. So those are some of the things. The review meeting takes about an hour and a half to 2 hours, and that may seem like a god awful time, but long time, but you'd be surprised how fast that time goes when you get into this. We generally will set a flat fee for follow-on services. Again, for those attending this webinar, there's a 5% discount. And generally there's a $300 review meeting fee that we charge. And if we do the review meeting by video, which is a lot of times we're doing these days, we'll ask for the $300 to be sent in advance. And that does not count follow-on services. That's an additional fee. But you will find that $300 is really well spent, because at the end of the day, even in the best case scenario, you'll get a clean bill of health, and then you can rest assured that things are in good shape. Okay, concluding slides. Just to remind everybody, you could chat us a question. There's a little chat, it looks like a little circle. You should see that if you want to send a chat question to us. Today's webinar, as you know, is being recorded. This is a way to get a hold of the recordation of this webinar, which will include both the video and audio. So you got to go to my website, jamessidelaw.com. Then you'll click where it says see our latest workshop, and then you'll subscribe to our YouTube channel, and then you'll be able to choose today's webinar as well as any other webinars. This is our friendly secretary, Linda. So when you contact our office, this is who you'll be dealing with. She said I thought I should tell everybody that we only have a few more bookings in April, and then we're into May. So if you're anxious to get something done, give her a call. Unfortunately, I don't know if the rest of your experiences, but it looks like we're having snow here. So it's possible she will be off tomorrow, and then of course she's off Saturday and Sunday, and Monday is a holiday, so she won't be back until next Tuesday if we have a snow day tomorrow. How to contact us. So there's the phone number, 434-964-0366. You can contact us by email at office@jamessidelaw.com, and by web, jamessidelaw.com. And there's a place where you can contact us. You can request a copy of today's PowerPoint slides, introductory booklet, evaluation sign-up form, and we actually have a 5% discount certificate that you'll be given that will again allow you 5% off our quoted fees if you do review meeting and there's follow-on services. Just to let you know, we've got another one of these webinars in April 6, 2021. Basically, we're going to be covering the same stuff. So if you know family members or friends who can profit from this, please do. I work very closely with the Virginia Cooperative Extension, and I'm doing 3 workshops with them in April and 2 in May. And I do that. One of the people that joins us is David Wise, and David was going to join us tonight. I don't know if he made it, but he will be one of the co-presenters for the Virginia Cooperative Extension presentations. Okay, so once again, if you got any questions, we've got, looks like we got one chat. Yeah, so Ron, he's talking, the question there is making the checklist, the funding meeting checklist available. Might I suggest the easiest thing to do is to call our office and we could send that into you. I guess we could try to make that available. It's
What checklist are we referring to?
they're talking about the funding checklist. I'm thinking that's what the person's asking for.
Yeah, if they call the office and ask for the funding checklist, give us their email address. We'll email them a copy.
Yeah.
I see that comes up as N. I don't know if that's 3NW or not.
That's just the name of the person.
Right.
Yeah.
But when I look on the list, N is not listed. We have a 3NW. That's the only N I see.
Yeah, I'm gonna go ahead and unmute everybody, so that if you do want to, verbally ask any questions, we're open. Now's the time. You got two on-scene experts.
Hey, Jim, this is Paul Zorko. You had mentioned earlier the thing about getting the review, I guess it's called a review plan checklist there. Is that what we're talking about?
Yes.
Okay, if we can do that, I'll send a message to Linda about getting one.
You're assuming what? Again, I didn't hear you.
No, I said I'll send a message to Linda about getting one of those. Review plan
Say you
checklists.
want a checklist. We actually have, let me see, it's actually a packet of paperwork that will bring you up to snuff. And it's got this nice checklist, like, have you gotten all your real estate in? Have you gotten all your life insurance in?
Right, that's the one I'm looking at there.
If you do that with us in a review meeting, we'll actually give you a grade. And we want all our clients to get an A.
Yeah,
So
we had ours done about 3 years ago with Sonia right now. So
yeah, I will tell you, the single biggest problem with living trust, bar none, is people don't get it funded. And when people come in and they say, "Oh, I had an awful experience with the living trust when my parents died," I will always ask them, "Well, was it because of probate?" And they'll almost always say, "Yes, it was because of probate." Well, that means the trust wasn't properly funded, because if the trust was properly funded, you wouldn't have had to have probate. So, I had a case this week. A $3.5 million case, and this was easy to miss. But the guy had a co-op credit worth some money, and didn't know about it. And the co-op credit union or something or another would not release the documents or release the money until they opened up probate. So it was a little bit of shame, because it was only a couple $1,000, and so they had to open up probate. They were able to do that on their own, so it wasn't too expensive. I think they still made out okay. But that's an example of where you couldn't avoid it. But you want to try to avoid probate, in my opinion, at all costs. I think I've got everyone unmuted here. So if you want to ask, I think we've got another. Okay, gotcha. Yeah, Robert Weinstein. So Ron, that mysterious caller you can see on chat, he's given us his name. Well, I'll bide my time.
I see that. And I responded, call the office, and either Linda or I will email him a copy of that. Or if he wants a hard copy, we can put it in the mail.
Interesting development since this COVID for my office is that in the past, most of my business has come from new clients that are generated by in-person seminars. And I've done hundreds of them over the years, and that's where I generally bring in new clients. Well, you can't do that in the COVID crisis. So most of my clients have been returning clients and we're honestly literally swamped. And I guess I feel very proud that we're getting people come back to us, because that's a real vote of confidence in us. And we really want to make all of our plans work. And sometimes that's not going to happen if we don't review your documents to see any updates that need to be done. The other thing we can do is, if you have done funding since the last meeting, we can look at the documents to make sure they're done correctly. I mean, on occasion, I look at on deeds that have been done that, in my opinion, are seriously flawed, and then we'll have to do a deed of correction. That's something we'll do. Well, I will tell you, this crowd is hanging in there. Yeah, we had about, like I said, we had 18 people registering, so we feel that's a good turnout, and we're hoping to do the same thing in April. I hope that you agree that we've given you some good information. I mean, in a sense, this is obviously here, we were trying to generate a return business if we can, but we also want to make sure, more important than that, just to try to get information out of this. So we hope we accomplish that. Ron, you got anything you want to add?
No, but something did pop in my mind, and that is upon the death of a spouse, if you have an LLC or set up, a lot of times people forget they may have to change their registered agent. And sometimes if you move, you may have to change your registered address. So that's something that people do forget to do, that they really need to do, is
Yeah.
to do the amendment, not amendment, do the minutes of the meeting to reflect the passing of the other person in the company. And also Jim alluded to the fact that you can use those LLCs, you can make gifts of interest every year, at least $15,000 a year per person without having to file a gift tax return. So you can sometimes decide what you're going to do with your business. If you want it to go to a particular child, but the other one doesn't want it, then maybe you would discuss with us the use of an insurance policy that the company would pay for. So when you passed, there'd be money, insurance money, to pay the child that doesn't want to deal with the business while the other child keeps the business. So we've had that come up quite a bit. So I just thought I'd add that.
Yeah, yeah, go ahead. So another thing I will also say is that, for if you're going through a situation where your spouse is disabled, it's really important to come in. We just handled a case yesterday where the disabled spouse was the registered agent, and during his periods of disability, he wasn't filing the necessary forms with the state of Maryland, and now they're threatening to lapse the whole LLC because of the failure to report. And I think we're going to catch it in time. And the surviving spouse the wife did not even know that the reports weren't filed. So because she was sort of the inactive spouse with regard to the limited liability company. Okay, seemed like a very attentive crowd. And again, we're standing by if you want any chance, final questions. Third call. And I appreciate everyone joining us. And again, feel free to give us a call to get information. If you can't figure out how to get to our YouTube, and by the way, if it's a snow day, the YouTube is not going to be set up until next Tuesday. If you want to get a recording, or for that matter, anything else, since Linda will be out of whack tomorrow, out of commission, I should say, if it's snow. All right. So
just want to thank you very much, Jim and Ron, for your time this evening.
Thank you very much for everything.
Thank you, Jim.
You're welcome.
Thanks, Jim. Thanks, Ron.
Yeah, thanks, Jim. Stay
God
warm.
bless you guys all, and look forward to seeing you all again.
Thank you.
No, thank you.
Welcome.
Thanks, Jim. Bye.
Thank you. Bye-bye.